Hey friends, good afternoon. Join me for this wonderful story that I'm going to share with you about how our client, we got great news today, guys. We got great news. I was actually planning to come before you about a different testimony, okay? And I had it all prepared. I was going to share this great testimony from a marriage case with you. And then I got this call and it changed everything. So I'm going to share with you how our client, who has been in the United States for 32 years and has made a number of attempts to get a green card, but could not do so due to his removal proceedings, how we were able to get ICE to approve our motion to reopen his removal proceedings so that it may be terminated or dismissed so that he could apply for the green card before USCIS. I'm so excited to share this one with you. I see that folks are joining. Share this live session with your feed. If you're joining live on Facebook, if you're watching the replay, share this with other people as well on WhatsApp, and give me some hearts, likes, and let me know what you think about this story. But this is to encourage those of you who are out there and you may have found yourself in removal and a judge has issued a removal order against you and you're eligible for a green card, but because of that removal order, the government will not allow you to get the green card through USCIS. If you're out there and you're in this type of scenario, I want you to watch this because this will surely encourage you to try again, okay? To try again. Because like I said, after 32 years, our client has finally got that good news call today from his lawyer that the government agreed with us and they're going to help you. They're going to help you close this, reopen your case so that it could be dismissed against you. And now you could apply for that green card through your US citizen son. All right. This is very emotional for us here today at McBean Law because this could not have happened to the sweetest man who is up there in age. Okay. Up there in age. And his wife is also elderly and sick. And this is the call that they got from us today, and it really melted all of our hearts. So join me today in this live session. I'm Latoya McBean Pompey, for those of you who are new to me, an immigration lawyer in New York, working with clients all over the world. Let's talk about how this happened. And if you need to contact us, you may contact us at McBean Law at 516-866-3900 or visit us at mcbeanlaw.com to schedule your consultation. And guys, I do need to say that the jurisdiction where ICE has approved this is in the South. It's in one of the toughest jurisdiction for immigration in the country, okay? In the South. So let's talk about what happened here and how this is so significant here. All right. And if you're still with me, say that you're still with me. I'm not sure if I'm still live. Am I still live? Are you there? If so, just give me some hearts or say I'm there, I'm here. I could still see you and hear you okay, because on my end, it's not clear whether the live session is still going on. I'm on? Okay. Thank you for that. Something else is going on here that's funky. The comments are not popping up. All right, but give me some hearts to let me know that I'm still live. Okay, so let's talk about this, guys. So the client came into the country in 1989 when many of us were still children, right? 1989, and he's married. Wife filed for him, and this is the usual story. Came in on a visa, overstayed. Spouse filed for him. That petition didn't go through. His application actually was denied. And after that denial for adjustment of status, like many of you, the government placed him in removal proceedings. And he was issued a notice to appear in 2000, okay? In court, he sought cancellation of removal, Okay, he applied for cancellation of removal because by that point he was eligible for it. He was eligible for it and he didn't get it. The judge did not agree with the application, and consequently, the judge issued the judge did, rather than issuing a removal order against him, they agreed for voluntary departure, okay, VD. And with voluntary departure, friends, if you agree to it and you don't leave the United States, it does turn into a removal order, okay? So now, fast forward to some years, and one of his children grew up, one of his US citizen children grew up and filed for him. And the I-130 was approved, but because the client was still had removal proceedings, a removal proceeding pending, so to speak. There were some other things going on, actually. Let me back up. Before the son filed for him, he appealed the judge's decision. He appealed all the way up to the BIA, and the BIA dismissed it. Okay, they denied his case. And so then when his son grew up and his son filed for him, the problem is this: USCIS cannot approve the I-485 adjustment of status application. Can't approve it because they don't have jurisdiction over him. The judge does. And the big problem that many people have in this scenario is that they cannot bring their green card application, the adjustment of status application, before the judge unless the proceedings are reopened again. All right. And so this is the situation that our client found himself in. He had an approved I-130, but he could not adjust his status. And so when he came to us after these many years, because his son's petition was approved in 2014, when he came to us a few months ago, he came to us because, they heard that the Biden administration has brought prosecutorial discretion back. Maybe there's a chance that McBean Law can take a look at my case and see what they could do for me, because I feel stuck. I'm much older now. My wife is sick. I have been trying to get a green card for all these years. Nothing was working out. So we took his case because we knew that we could we could do the prosecutorial discretion request to that very difficult ICE office in the South. And we advised him that this is going to be difficult because of that jurisdiction. They are extremely tough, very, very tough. But we think you have a good chance here. Let us do this. And he agreed, and we prepared the motion to reopen his case. And we submitted that to ICE. And we could, by the way, we could do this for you where it doesn't matter where you're at in the United States, because this process is largely administrative and electronic, and we can do it for you wherever you're at. And so we submitted the request in August, at the end of August. And today my colleague called that office, the ICE office, and they said, we've agreed to do this for him. We agree with you, and we're going to go ahead and we're going to prepare this and send it in so that his case can be reopened. And then after the case is reopened, after the next couple of months, we will then prepare his green card application so that he could get his green card through his US citizen son. That's how it happened. Okay. And so not all cases, guys, I'm just going to say this, not all cases. Someone hit the nail on the head. Thank you for joining from the South, as I see some Southern people on here as well. So it's tough. It's tough, okay? I won't say which which office did this for the sake of the privacy of the client, but it's super, super, super tough there. In any event, if you're in a situation like this and you need your case to be looked at, whether you use us or someone else, have it looked at, okay? Have it looked at. Because if you have a petitioner and a pathway to that green card, you may have a chance of getting your case reopened so that your application can be submitted to USCIS so that you can get that green card. Now, not every case is eligible for this type of discretion, okay, with ICE. If you have a lot of fraud and some other stuff on your record, we would have to balance out the fraud with, you know, some other positive factors about you and make a stronger argument for you. Also, if you don't have any pathway or any form of relief, that's going to be a problem as well, because you need to be able to demonstrate that you do have that pathway. If you're in this situation, I highly encourage you guys, let us take a look at it so that we, might be able to help you to be able to apply for your green card. So I'm just really thrilled for this family today because they didn't give up after all these years. 32 years, guys. They didn't give up. And there's this opportunity now under the Biden administration to do prosecutorial discretion, to submit that request and ask ICE to use their discretion to help you to close your proceedings so that you may pursue your green card application before USCIS. So this is thrilling for us, and I wanted to jump on here real quickly and let you guys know that what is possible, and reach out to us again at 516-866-3900 or at McBeanLaw.com. Be patient if you want to meet with me. It's my schedule. I'm not available like within a week or two. Just be patient. Get on my calendar. If not my calendar, get on one of my colleagues' calendar, because my colleague, she prepared this motion to reopen and she did a solid job on it. And it was a team effort, but we made it happen, and our client is extremely happy. So trust us, trust our judgment. And if you've met with us and we've told you in the past, you know what, we think we need to do a case assessment to see if you're a good fit for prosecutorial discretion, or let's study your case to see if we could really do this motion to reopen for you the right way. Trust that recommendation. Okay, trust it, because we have to study it first and we have to really look at a lot of different variables in order for this to work. That's what we did for our client, and it worked. So guys, again, if you're in any part of the United States and you have a removal order and you're not eligible for a green card through a relative, but you're stuck, the court won't open your case or the BIA dismissed your motion to reopen, contact us so that we could take another look at that for you. Okay, and lastly, as I go, I do not have an update on pathway to citizenship other than the House will be voting at the end of this week on their BBB, Build Back Better Act, and the CBO is coming out with their score. The score has to come out first before the House votes on it. The Senate is saying that they're going to vote or wrap things up by the end of December. Okay, they're looking at the end December for on the Senate side. The parliamentarian has not weighed in yet on the Plan C, which is that 5-year parole work authorization language, and also the language about recapturing unused visas that would allow folks to be able to apply early for adjustment of status. So she hasn't weighed in on those issues yet, but some people are very optimistic that it will work out favorably. Pathway to citizenship, on the other hand, is something that that has fizzled down. Okay, there's no political will and appetite on the Democrat side for this, so that's very disappointing. But that's where things are at right now. Guys, I'm going to jump off here, but I wanted to come on and share this good news testimony with you. Thank you so much for being with me, and share the video with other people, and contact us at McBean Law so that we might be able to see how we could assist you. Have a wonderful evening, and I will see you in the next one. I will be back before you. I have a video coming out this week on another topic that I think many of you would be interested in. So stay tuned for that. And then if there's any updates from Capitol Hill, I'll try my best to jump in front of you. See you soon. Bye-bye.